Mr. Walker, the official timekeeper tells me it's 5:30, so we're gonna get started. This is the Thursday, July 30th, 2026 meeting of the Blowing Rock Board of Adjustment. We'll come to order, and the first thing we have to do is take a look at the minutes from our meeting of May 28th, 2026. Did everybody on the board get a copy of those minutes?
Yes.
I myself didn't see any problems or omissions. Did anybody see any problems or omissions? I make a motion that we accept the May 28th, 2026 meeting minutes. Is there a second? Mr. Schiller seconds. All in favor of accepting those minutes as distributed by Ms. Miller, say aye. Aye. It's unanimous. So that's taken care of. I don't have any new business to take up before we get into the variance hearing we're going to do. Does any board member have any new business he wants to bring up?
No.
Okay, all right, we'll move on then. We have a variance application. It's variance number 2026-03. The applicants are Fred and Sandy Ceretti. And Mr. Ceretti introduced himself to me. Is Miss Sandy Ceretti here?
No, she is not.
She is not, okay, all right. The location of the property that we're gonna be talking about is 369 Tarry Acres Circle here in Blowing Rock, North Carolina. And first thing we need to do is find out if any board member has any conflict of interest in this case. And I have a little list here of things that we have to address. The board members cannot discuss this case with anybody prior to this hearing here tonight. Has anybody had, that's called ex parte communications. Has anybody on the board had ex parte communications, talked to anybody about this case prior to this evening? I haven't.
No.
Everyone says no. A member must not have a fixed opinion prior to this hearing as to whether this particular variance should or should not be granted and should not be biased. Does anybody have a fixed opinion about this before we even start?
No.
No? I hear no from everyone. A member must not have a fixed opinion as to whether all variances in general should or should not be granted, should not be biased one way or the other. Does anybody have such a bias?
No.
No. No from me, no from everybody. A member must not participate in this case if the member has any close familial, business, or other close relationship with the person involved in this case. Does anybody have a close relationship with anyone involved in this variance application having to do with 369 Tarry Acres Circle? Anybody? Everyone says no. And a member must not have any financial interest in the outcome of this case. Does anyone have any financial interest in the outcome of this case? And we all say no. We, board members, are not allowed to discuss this case prior to tonight, the ex parte conversations I just mentioned, but we're allowed to drive by the property in question and look at it, give it a good eyeball. And we're allowed to do that just so we don't stop and get into some sort of conversation. We just look at it and keep going. I know I did. Did any other board members go by 369 Tarry Acres Circle?
Yes.
I have, yes, yeah. Everybody but Mr. McGill, you did not.
I read my
Oh, you
paper.
did, Mr. Schuler did not too. Mr. Schuler and Mr. McGill did not go by the property.
I read all the material we was given though very thoroughly.
Okay. Okay. The other three of us did go by the property. Is there anyone other than the town representative and the variance applicant who considers himself to be a party to this case, wants to come into this case as a party and participate fully because they feel like the outcome of this case, one way or another, may affect them? Anyone here that feels like he is a party to this case? And I hear nothing. minutes of this meeting are going to be kept by Ms. Taylor Miller over here. She is a town employee. She's actually works in the planning and inspections office. Mr. Surretti, do you have any objection to Ms. Taylor keeping the minutes
Not
here?
at all.
Okay. And Mr. Johnson, do you have any objections?
I do
to
not.
Ms. Miller keeping the minutes? Very good. The North Carolina Court of Appeals has said on a number of occasions that we are supposed to let everybody here know what procedures we will use. And they have given a suggested spiel to take care of that. This hearing is a quasi-judicial hearing. It is conducted according to the rules and laws pertaining to quasi-judicial hearings. It will have all of the essential elements of a fair trial. Parties will have the opportunity to give evidence, cross-examine witnesses, inspect documents, and testimony shall be under oath. The board's findings will be based upon substantial, material, and competent evidence. And if anybody here wants a definition of substantial or material or competent, say so now and I'll read it. Otherwise, we'll move on. Mr. Johnson, I asked Thomas to put two sheets into the projector up there, both of them showing what's required for variance. And there's the first one. That is the state statute that shows what is required to get a variance. There's a state statute on this. It's North Carolina General Statute 160D-705. It gives the requirements for obtaining a variance. It's the law we are to follow, the law we are to apply to the facts that come out in this hearing. So that's the state statute. If you would turn to the Blowing Rock ordinance. That's the state statute.
Did you have a sheet?
Yeah, I gave it to him.
Scroll down.
There we go. Blowing Rock, the town, wrote its own ordinance. The town's ordinance has to comply with the state statute. The state trumps cities and towns, and it does. It's virtually written identically, showing what we call the factors, the 4 factors that have to be met before a variance can be granted. Blowing Rock added a few little things, explanatory things, like the last sentence in factor D reads, the requested variance is consistent with the spirit, purpose, intent of the regulations, such that public safety is secured and substantial justice achieved. That's what the state statute says. Blowing Rock went on and added this. They say substantial justice is not achieved when granting the variance would be injurious to the neighborhood or to the general welfare. So let's look at the 4 factors real quick that the Surrettis will need to prove and establish to get the requested variance. The first says unnecessary hardship would result from the strict application of the regulations. It shall not be necessary to demonstrate that in the absence of a variance, no reasonable use can be made of the property. What is unnecessary hardship? It's not defined in the state statutes, it's not defined in the Blowing Rock Code of Ordinances, and it's not defined in the common law, judge-made law of this state. The people, however, that train the legislators in Raleigh, and they go around the state and train town councils and county councils, the UNC School of Government. they have talked about what unnecessary hardship is. Their professors are also lawyers who specialize in land use and development. And they would say, the School of Government attorneys and professors would say it's fair for all the property owners in our neighborhood to suffer the same degree of hardship due to the zoning rules. But it would be unfair and excessive for the zoning rules to impact the property more than the other properties in the neighborhood due to unique characteristics of the property. That's excessive. Actually, the adjective unnecessary is a poor choice. You might think of it as excessive or unfair hardship. So basically what they're saying is if you've got some problem with your lot, whether it's a very steep slope that takes up most of the lot, a stream going through the middle of the lot, or maybe you're a long, skinny rectangular lot, and you can't do much of anything as far as reasonable building without getting into the setbacks or breaking some other zoning rule. Your property has unique circumstances such that you need a little help. But your property's got to have those problems. And so that needs to be established. That's the first thing that needs to be established to get a variance. The second says the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. And the third factor says the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of the variance shall not be regarded as a self-created hardship. And then the last one, D, the fourth one, I think I read earlier, it says the requested variance is consistent with the spirit, purpose, and intent of the regulations, such that public safety is secure and substantial justice achieved. And Blowing Rock is tacked on substantial justice is not achieved. Granting the variance would be injurious to the neighborhood or to the general welfare. Our usual routine is to swear everybody that's going to be testifying all at one time. So everybody that's planning on testifying, please come over to Miss Miller, and she will swear in everybody at the same time.
Do you solemnly swear that the evidence you shall give to this body in this matter being heard shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Serrata, you're the property owner. I know there are going to be questions for you, but do you mind being sworn in?
No,
I'll take care of it.
Do you solemnly swear that the evidence you shall give to this body in this matter being heard shall be the truth, the whole truth, and nothing but the truth?
Thank you, sir. When someone applies for a variance, the Planning and Inspections Office prepares what's called a staff report. It's a type-up of what their understanding is about what the applicant wants to do, and they include with it any drawings, pictures, or materials that the applicant has provided to the Planning and Inspections Office. A copy of that staff report is sent to the board, and it's sent to the applicant, Mr. Sreddy. Did you get a copy of the staff report? Okay. That was put together by the town, and they are a party to this case. You're the other party in this case. If this was ever appealed, it would read Fred Serrata versus the town of Blowing Rock. So they put it together. They are, so to speak, kind of your opponent here, your polite opponent. do you object to any part of the staff report that they put together?
No.
Okay. Board members, you've all received the staff report. All right, generally, we start with what the town knows about this case. And Mr. Sweat, do you mind if the town goes first? If you really want to go first, you can go.
Yeah.
Okay, all right. So, Mr. Johnson, you gonna take care of that?
Yes, sir. Chairman, board, staff report for variance number 2026-03. The applicant is Fred and Sandy Serrati. Fred is here, obviously. 369 Terry Acres. It is zoned R15 single family property in reference. Just for y'all's reference, this is the property in question here. Terry Acres, 369 Terry Acres. Fred and Sandy Serrati are requesting a setback variance from Land Use Ordinance Section 16-12.4 and the applicable 12-foot side setback along the western property line for the construction of an accessory building. Property is located at 369 Terry Acres and further identified by Watauga County PIN 2817-43-7159000. Again, the property is owned R15 single family.
Let me interrupt. Are you reading from the same typed first page that we all got?
Yes, sir.
You're bouncing back and forth. Could you, could you start from the top and go from there?
I'll start in the background. It's the same thing.
Okay.
So Fred and Sandy are requesting a 2-foot setback variance. This is from the applicable 12-foot side setback along the western property line for the construction of an accessory building. The accessory building dimension is 11 foot 8 inches wide by 13 foot 8 inches long and is located on the western side of the existing house, which is on this side here. This is the western property line. This accessory building sits about right here in this location. A little bit of background. In March 2026, Mr. Kevin Rothrock, Town of Blowing Rock Planning Director, and myself as Zone Enforcement Officer with the town, made a site visit to Mr. Serrati's property to assess possible work without permits. It was found that several areas of improvement had been constructed that would have required a permit, which is the accessory building that's on the property now. Mr. Rothrock contacted Mr. Serrati and advised him that a zoning permit was required for the work that had been done. At this time, it was just the foundation for the accessory building. The building hadn't been built yet. So all that was there was the pad, the foundation for the accessory building. Mr. Rothrock informed him that the work for a proposed accessory building structure at that time would encroach into the side setback when placed, would need to be set at an angle and offset on the retaining structure to meet the 12-foot setback. The structure that was there was determined to be a retaining wall in nature, or retaining pad. So the determination was made to allow the wall as it was, but what Mr. Rothrock had advised him is that the accessory building would need to be turned on the pad to meet the 12-foot setback. So the pictures you have in your packet, there's several pictures that Mr. Serrati has included in the packet. They're showing, and we can go over them, showing where the property line is in relation to the building and where it goes through it and where the encroachment is. Moving ahead, Mr. Serrati applied for a zoning permit application on April 6th, 2026. And subsequently, a zoning permit was issued on June 24th, 2026. While the zoning permit was issued in June, Mr. Shreddy submitted a site plan, which is included in your packet, showing the proposed building structure and the footprint that it would meet the required 12-foot setback. During that time, Mr. Rothrock had made it clear that the structure would need to meet that side 12-foot setback. Mr. Strady contacted the plan inspection office and indicated the structure had been built and the left rear corner encroached 18 inches or so into the setback. At that time, Mr. Johnson, myself, had advised Mr. Shreddy that the building structure would need to be moved on the pad or moved out of the setback. On July 2nd, 2026, Mr. H.E. Weathers, apologize if I don't know your first name, met with staff in the office to determine options for Mr. Shreddy. And staff once again advised that the structure would need to meet the side, move to meet the side setback. And Mr. Withers at that time decided that they wanted to apply for the variance to discuss and possibly apply for the variance to allow the encroachment. Be glad to go through any clarification on this background. Be glad to look at any of the photos. I can pull them up as well to clarify anything on those. And Mr. Shreddy may be able to answer, or the two gentlemen may be able to answer more on the photos that was submitted.
Mr. Soretti, do you have any questions of Mr. Johnson?
Sorry.
Do you have any questions of Mr. Johnson?
Well, I mean, I just want to make s- clarification back, with respect to the permit and everything else other than what we're talking about today. When that two-page report came out, that was the first I knew that I actually got the permit after the fact on everything else we did on the property. So, but I didn't think that really pertained to this particular,
I tell you what, after we finish with him, then I want you, please, to present your case. And
I mean, I'm trying to be truthful here. I did not know that I got a permit on something I didn't apply for.
Okay, and we want to hear,
Okay, so that's all I'm saying.
we want to hear your whole story, but let's,
Yeah, no,
at this-
that's
at
just a
this point-
sidebar as far as I'm concerned, but I just
okay.
want to be clear that that's the first time I heard about that was when you wrote up the two-page report.
Okay, I'm fuzzy on that, but we'll get to you in a minute. Do you have any questions, Mr. Johnson?
No.
Okay. I've got a number of questions. Any board member have any questions of Mr. Johnson? I see Mr. Walker showed his. Go ahead.
Any certain pages you want me to roll through the staff report here?
One, I don't think that I received in the packet the permit application showing the building meeting the zoning requirements. Did we get that?
No, it wasn't in there.
You mentioned that as part of the permit application, there was a document
A
presented.
site plan that showed
Yeah,
the
site
building in
plan.
compliance with zoning laws.
Yeah, it should have been right after your application in the packet.
You have it up on the screen there?
Right, that shows it not meeting the setback, doesn't it?
You're talking about the original permit request that I wrote up?
In April? Yeah.
Would you want me to make copies of this?
I'll make.
So this, my apologies, this was in the zoning permit file that Mr. Shreddy had submitted. That's different than what you see here. Let me make a copy and you can take a look at that. That one was in the actual zoning with the zoning permit application.
And, in March, what prompted the property visit?
We received a call that there had been work done, and I think Kevin may actually have been by the site as well.
About the same time, there was some appraisals done on my property anyway, so not sure that
Yeah,
was.
we've got other projects going on up in the area as well.
And in March, I'm just trying to get some more detail. In March, you said there were other projects going on that would have required permits. Is that beyond the shed?
So the site visit was to determine, when me and Kevin went out to determine what needed permits. And you come back to, that the accessory building needed a permit.
And how was it determined that the foundation of the accessory building is a retaining wall?
So when it was built at the time, I mean, it was basically a retaining wall for pad. So we determined that was basically a retaining wall. Because they've got a little patio in the front of, and you may have seen that when you rode by.
I did.
That there was some retaining walls associated with that as well.
Doesn't a retaining wall that height require engineering studies and a lot of?
If it's
I think
over, if
3
it's
feet.
over 4 foot, it
4
does.
feet.
Yes.
It is over 4 feet.
We would have to determine that. We'll determine if it is. And there may be, we can have this discussion through this, is at the time, Mr. Shreddy was looking at a 10 by 12, that's what he expected the building to be. And the actual size is, one dimension is 13 feet. So any building that's over 12 feet typically requires a building permit. So that's something we'll have to address to see what the exact dimension is. Minus some overhangs from the building code standpoint, it don't include those sometimes. We've got to make a determination outside of this whether a building permit was required or not. Now, that will be determined.
Okay.
And part of that discussion may be the retaining wall as well in the height.
And just timing, the permit was issued June 24th.
That's correct.
Was the building already built?
So when me and Kevin investigated, just like, again, going back, the foundation retaining part and the patio stuff had been built. And that's when it was advised he needed a permit, which was submitted in, the first week of April. And there was a time lapse of June, which on staff's part, that was our fault. But we still maintained what he submitted in that zoning application was 10 by 12, and it was going to meet the 12-foot setback. So when I sent the zoning permit, and Mr. Schrader called right away and was like, hey, it's been built, and I'm not aware, I know there's a lapse in the zoning permit.
And just, sorry to come back to this, but how or when will it be determined if it is a retaining wall? Again, I thought you had to have engineering studies, all kinds of stuff for a retaining wall of that height,
If it's over a certain height, yes, you do.
which, I mean, it's 4 feet, at least from my observation, it looked
And
well
we'll
over
determine
4
that,
feet.
sure.
So what happens if those studies were not
It may
done?
If it's over the height, then it may require him to obtain some engineering to make sure it's built right.
Yeah. Okay. Okay.
I'm still fuzzy on the retaining wall and the pad. Tell us again tell me more about, just repeat what you said about the retaining wall and the pad.
So when me and Mr. Rothrock was out there had been some driveway work done. There was some other retaining walls associated with it that included a patio out front. And we didn't know what the ultimate use was, being an accessory building or not. You can build a retaining wall. A retaining wall can be in the setback. There's just height limitations within a setback. And typically, they're limited to 6 feet in height for a retaining wall. So the way it sit there, we determined that was a retaining wall. It's sitting there and it's retaining the foundation for that. It's no different than him having a retaining wall built that's been there for years and he can go build on top of it. as long as the supporting is okay.
Is what you're talking about shown in the pictures? Can you pull up a picture that shows us?
That may be the best. We can zoom out of it if you need to, but the first site visit out there, this was what was there, not the structure. So this was what was determined as a retaining wall. Now, going back to any height requirements,
But now it's the foundation for the accessory building?
it's a building sitting on a retaining wall is the way we determined it.
Okay.
And so what Mr. Shreddy was advised was, we determined this was a retaining wall, because it's tied to other patios up in this area here. To meet the setback, you need to move the building on it to meet the setback, the actual structure of the accessory building to meet the setback.
Right. Could that retaining wall stay there and it be in compliance with the zoning rules?
Sure. If it's under 6 feet in the
It's
setback,
under 6 feet.
right.
But the little house, the shed, it is in the setback.
Yeah. So Mr. Shreddy submitted these. This will give you a little clear idea of what's in it. And he can correct me if I'm wrong during his presentation. This is where the property line angles into the structure there. And that's what you'll see on the site plan that's in your packet there. It's basically that minute section of the corner right. And I think they determined it was about 18 inches, or maybe some discretion on the eave of how much that's in it, but you're looking at about a 2 foot. It starts at nothing here and goes back, the back part on the back side would be 2 feet in it or so, 18 to 20, 24 inches or so.
Is that the eave of the building, wall of the building?
We may have to ask the applicant, and I'm not sure. There may be some additional encroachment with the eave.
And your presentation says March, you went up and looked at the property. Then it says in the next paragraph, Mr. Rothrock contacted Mr. Soretti and advised him that a zoning permit was required and that the building structure would encroach into the side setback and would need to be set at an angle. When did that happen?
I may have to let Kevin, if he's got his notes, and see what time that was.
I mean, it was between March and April 6th when the permit was
Right.
applied for.
Right.
Okay. And the building had not been built then.
As far as I know, no.
Okay.
I don't know. We can enlighten you on when the actual building was built. There's probably a process over time as well.
And then in April, a permit application was submitted showing the structure would meet the 12-foot setback, and Mr. Rothrock made it clear, I guess again, that the structure would need to meet the setback. And that again was before the structure was built.
Yes.
Okay. Okay.
So you can't tell us if the retaining wall meets the zoning requirements and is short enough to be within the setback. You can't tell us tonight.
These guys might. They may have.
These guys, what?
There's a ruler there.
What?
These guys can probably enlighten us on what the height of that is. There's a rule there, but I don't know what. I don't know if we'll be able to tell.
Mr. Johnson, why didn't you go out and measure it?
We're pretty sure it's under 6 feet there, though. That's why the determination was made. It's a retaining wall, and where it was at was fine in the setback. And Kevin might can testify a little bit on what our heights were there. But that height limitation is 6 feet in that setback. And I think if you look at that tape there, and like I said, we can ask these guys. It's probably pushing close to, but we need to make that determination.
in the building, have you gone out there and determined how much it encroaches into the setback?
Yeah, that's shown in these pictures, and that's the request of 2 feet. But there's a question on, we can ask them how wide the eaves are.
Okay, but you haven't measured it yourself.
No,
Why not?
it was never measured.
You did what?
It was never measured. There was no, they give us the information right here, and we didn't measure it.
Anybody else have any questions of Mr. Johnson? Mr. Johnson, I've got a few questions for you.
I have one question. Mr. Johnson, the permit was and was May 4th. When it was granted, the building had already been built.
When the zoning permit was issued, yeah, it was already built.
So, okay.
Is that all, Mr. Goodson?
Yes.
Notices, Mr. Johnson, do you know if all required public notices of this hearing have been sent out?
Yes, sir.
And have nearby property owners been notified of this hearing?
Yes, sir.
Did you hear back from any of the nearby property owners?
We heard back from one property owner.
How many notices did you send back out?
14. Is that including Mr. Fogelman?
Yes, there was 13 originally, and then we added 10 because he was a property.
The adjacent neighbor, Mr. Fogelman, was a recent property owner
Okay,
that just bought the house, so we ended up notifying him outside the address as well.
so you sent 14 notices?
14 total, yes, sir.
Let me make sure I've got all the information I need as far as background. What sort of new structures require just a building permit?
Anything that's over 12 feet in any dimension.
You said this accessory building is 11 foot, 8 inches wide and 13 feet, 8 inches long. Does that come within the 12-foot rule so that it needs a building permit?
It would need a building permit. If that's the actual measurement, yes. And we would have to check on the building code, and John can answer if we need be, but there is some things that may or may not exclude the eaves in the building code. That's aside of what's required. Eaves being required in the zoning ordinance, but building code's a little bit different, but we'll make that determination. But as it sits right now, yes, it is. It would require a building permit as well. And I think it was 2 or 3 weeks ago, I reached out to Mr. Soretti just so I'd know in the staff report the size of the building. And that's what he told me the dimensions were.
So tell me about the eaves. The eaves are included in any measurement from a lot line, right?
That's correct.
Does this building have eaves?
Looks like it does to me, yes. But I don't know the widths, and they can probably enlighten what the widths are.
It's about 4.5 inches from the retaining wall.
Mr. Johnson, what kind of structures require just a zoning permit?
any structure that would be, on accessory building period, any size requires a zoning permit, and that's for verification of meeting setbacks. Building code don't kick in to 12 feet and above.
Okay, so if your accessory building is less than 12 feet, you don't have to get a zoning permit.
That's right.
You get a building permit.
That's right.
No.
No, you don't,
Okay.
12 feet and under, it didn't need a building permit. 12 foot and greater, yes, you do need it.
Greater than 12 feet.
12 and greater than 12 feet. So
It needs a zoning permit.
right. So 10 by 12 would not require it.
Okay.
Yeah, so just for reference, accessory buildings, this is section R101.2.1. The Building Code, International Building Code says accessory buildings with any dimension greater than 12 feet shall meet the provisions of this code. So 12, above 12.
Above 12, you need a building permit.
That's right. Correct.
Above 12, you also have to get a zoning permit.
Any accessory building requires a zoning permit.
So you're gonna have to
It's
do,
not 12, it's not based on 12 feet.
No.
Zoning permit's required.
Any structure, we have to verify setback. Decks, accessory buildings, homes, buildings, anything. That's not based on a certain dimension,
okay.
but that's verification to meet the setbacks.
You went out there to see if there was work being done without a permit. What, I take it you found that work was being done without a permit.
That's right.
Without what permit? What permit should they have had?
Well, it was determined what permits they would have needed. And the determination was at that time that they needed a zoning permit.
Because all accessory buildings need a zoning.
Yeah, I mean, and a lot of times, any land disturbance, if it's, you're getting into significant land disturbance, you need a zoning permit. Even if, a lot of times, if walls are, it's kind of a discretion call, depending on the height of the wall, may or may not need a zoning permit, but that's different than the 4 foot of requiring engineering in the building code. But the zoning permit is based on, not solely, but based on meeting those setbacks.
All right, would a property owner who was getting ready to build an accessory building, this accessory building, would they need to get their permit before they started work?
Yes,
And had the Cerritos obtained a permit before they started work?
no. So when the zoning permit application was submitted, Mr. Shreddy included the site plan that you have there, showing 10 by 12. Typically, zone permit is issued. However, we rely on going and doing a final inspection on something and making sure it meets what was submitted, even though there was a time lapse in that zoning permit. So we're assuming a 10 by 12 is going to be meeting the side setback.
Where were you getting the 10 by 12? I'm looking at the drawing that shows the shed intruding into the setback, but there are no dimensions on the shed. Where you're saying 10 by what? What size?
Yeah, but it does, it says 11.4, this is on the zoning permit site plan. So if you show the 12 foot that's shown on there, that's him showing the setback.
Okay, we don't have the zoning permit?
No,
On the actual application, I wrote generically 10 by 12. When I filled this out, I had, put more precision in the pad itself. And I said 11.4 by 13.6. It's now 11.8 by 13.8, so I was off by a few inches. But I did not signify that I was within a 12-foot setback. I made no, in fact, I told Kevin it's close. I didn't have an as-built survey done, nothing done. I brought this request.
All right, hold that thought. We want to hear more about that. Let's finish with him first. Okay, so as far as the accessory building, when you went out there in March, the retaining wall it was gonna sit on was there,
That's correct.
and well, I was gonna ask you what was in Mr. Rothrock's mind. I'll have to wait and talk to him in just a minute. Have you measured the accessory building since it was completed?
I haven't measured it, but it is complete.
Right.
I've been on site and it's complete.
So Mr. Soretti has told you it's 11 foot 8 inches wide by 13 feet 8 inches long, but you
Yes.
haven't measured it.
That's right.
So the building is encroaching into the 12-foot western side setback by how much?
So going to this picture, they show a measurement here. Let me get to it. So that's the bottom corner of the accessory, the bottom of the accessory building there that's showing 10 feet. So that's to the wall. So that's telling me you need to add the eaves to that as well, which Mr. Reddy said was 4.5 inches. So you're looking at 10, you're looking at, actually there's an inch on there, my apologies. So you're looking at about 2 feet, 5 inches or so. Including the eave.
Into the setback.
Into the setback, that's right. And that's the furthest more to the point of that corner. And then it's less as you go towards the front of the building. Towards that point that you see right there.
All right, and the maximum point of encroachment, it's
It's
Give it to me.
27.5 inches.
So 2.1 inches, 25 inches, and plus the 4.5 that he just mentioned was the eaves. So you're looking at 25.5 inches there.
that it encroaches into the setback,
Yes.
25 and a half.
It'd be 27.5 once you add the eaves back to the 23 inches that the stone wall's encroaching into the setback.
So 24.
Correct. So 23 plus 4.5, 27.5.
No, it's more than that.
Technically, it's 4 inches, but it's not at a right angle, it's an angle, so it's only a piece of that.
So it'd be 24 inches plus 4.5 inches.
Right, okay.
So 28.5 inches.
Is the total encroachment including the eaves?
Yes,
28, what was it?
28.5.
28 and a half. So they have requested a 2-foot variance, and that's not gonna take care of it, is it?
It sounds like it's not. That's going off the measurement. Looks like you see in that picture of 24 inches and 1 inch, 25 inches. That's to that foundation wall.
Was a permit issued for the foundation wall at any point?
No,
And it was never measured.
no.
And I looked it up. It's any retaining wall exceeding 5 feet shall be designed and constructed under the responsible charge of a North Carolina registered professional engineer. Engineer shall submit a sealed report including final approval on the retaining structure construction to the building code official. So none of that happened.
Is that in the ordinance, the
That's
town's
in the ordinance.
land use ordinance?
It's 16.11.2.1 part B.
That's right.
So that never happened. None of that.
But it could be included in a zoning permit,
But it,
but you'd have to have engineering if it's certain
but
height.
it wasn't, so none of that happened. Okay.
All right, Mr. Serrato, are you following with us on this 28.5 inches encroachment? Are you,
It's not quite that much, but
I mean, I never had an on-site survey, or as-built survey, he approximated feet or a foot and a half, but,
I think,
you know, we're doing our best. Where I think the property line is, estimated, nobody's really has a precise number, to be honest with you.
okay.
Or the retaining wall.
I'd have to refer to them.
I'll
Okay. Mr. Johnson, are there extreme problems with the lot? It's 369 Terry Acres Circle. By that, I mean extreme slope, or it's a very narrow lot. Do they have,
I don't think in this,
Extreme
I don't think that would have had a bearing on this instance. No.
are there places on the lot, the entire lot, where this accessory building could have been built without encroaching into any setback?
Yes. I mean, that was the solution, was to move that corner and meet the setback.
So could it have built just closer to the house? 2 or 3 feet closer to the house?
Probably, yes. Or it could have been a smaller building.
All right, you said when you and Mr. Rothrock went in March to the site there at 369 Terry Acres Circle, you saw construction that had been done without a required permit?
Yes.
And what all was it? Was it, tell us what all you saw that had been built that did not have a permit?
So this part was there, and all of this was there.
I can't see your red dot, but
All of this was there. Patio, and this part down here. And there was, looks like some of the driveway had been redone. Which, no issues there, I mean, been redone.
did the patio require a permit?
It could have discretionally required a zoning permit. And that's just to ensure compliance with any kind of, erosion control measures, verify any setback issues that could have been there. Building permit, probably not. Unless, based on the height, we just have to determine the height of that and see if it's over that threshold.
Well, what's the status of that patio as far as permits? Was there a permit issued for the patio?
At the time, no, but I mean, all of this work can be covered under the zoning permit we have here. We're fine with that. There's no issues with the patio.
Okay. So they got a permit after the fact?
That's right.
Okay, all right. And what else was there? The retaining wall / foundation for the building was there?
Right, yeah, most of it was more hardscape type stuff out here. And they can let you know, it looked like maybe they'd resurfaced the driveway, redone it, maybe reshaped it a little bit. We had no issues with that. Sometimes minor redoing of a driveway, but probably wouldn't require a permit. Just depends on how involved it is.
when you and Mr. Rothrock went out there in March, was there work going on, active work going on?
There was not at the time we were there.
Um,
Mainly, it looked like everything was done until, the accessory building come into play. And then they can let you know probably when that was built, what time frame it was built.
Is that building a stick-built building, or is that?
I think it was stick built, but they can clarify that.
Um, It says Mr. Rothrock contacted Mr. Sweaty, advised him about a zoning permit. Would you mind switching positions with Mr. Rothrock? I don't want to sit here and just do hearsay. So, Mr. Rothrock, you and Mr. Johnson went out to 369 Cherry Acres Circle in March of this year.
Yes, I went, to give you a little bit of background, I went first
Okay.
by myself, based on a call I had related to some drainage issues. And when I got to the site, there was quite a bit of work done. Fencing, not retaining wall, but more of a decorative wall around the driveway, and some drainage connections made. Nothing that was an issue with that. And then there were guys working, and they had completed a pad that you saw in the picture. This pad was under construction, and then the other pad, what we determined to be a retaining wall, was there too. And after that,
This was in March.
this was in March, I called Mr. I don't remember if Brian and I went back out to look at it then. I was just unaware of any permits that had been applied for at that time. And so I called, I think I may have called Brian and Taylor just to check, hey, are there any permits issued for this property? And I think Brian and I went back out. I don't remember if it was before I called Mr. Soretti or after. But we did let Mr. Soretti know that he needed to apply for some permits for the work. And at that time, he let us know that he wanted to put a building on that pad that you see there. And I said, well, it needs to meet the setbacks, 12-foot side setbacks. And when he brought his application in, we met with him in the office, and at that time, he had the concrete patterns that you see in what was copied for you. And I said, Mr. Soretti, you need to make sure that this meets the 12-foot setback.
This was the first time you talked to him.
Yes, first time I talked to him. And then that's when we went back out to the site to verify if that retaining structure met the setback. And apparently, at that time, it did not. And so I told Mr. Soretti it needs to meet the setback, and that I'll let Brian know that in reviewing this application, that if he wanted to put a building there, it needed to be shifted on the lower back corner because it was too close to the property line.
Right.
And to move, if he's going to build a building on it, it needs to be shifted over to accommodate the eave overhang and all that, because the building, that pad was encroaching a little bit. A question I think you had about the retaining structure. Retaining wall can be built right to the property line as long as it doesn't exceed 6 feet in height. You can also reduce the height of that by backfilling against the wall. That lower corner is between 6 and 7 feet above grade, and so that could be adjusted by backfilling the wall in that corner and reduce that height so it would meet the criteria for a retaining wall in the setback.
Your problem is the house structure. It's not,
You know, the structure, if he never put a building on it, it's fine the way it is and he can use it as a patio. Once he puts a building on it, it needs to be shifted in such a way to meet the setbacks.
when you had that first conversation, that was the first conversation you had.
Yes, and
You told him.
that's right.
You told him it was intruding into the setback.
That's right. And I had Mr. Soretti indicate that it would meet the 12-foot and he drew on 12 feet in this dimension from the corner to the property line.
Did he seem to understand what you were
I think
telling
so.
him in the conversation?
I think so. I mean, I thought he did.
And this was over the phone, I take it.
I didn't hear you.
This was on the phone, or this wasn't in person?
It was in person, in
It was
our
in person.
office, yes.
Okay, okay.
In the front office, we had the piece of paper and we were going over, you need to make these indications on the plan for us to review.
How did he know to come see you? You didn't see him when you went out there on the site?
No, we called him.
You called him?
Yeah.
And he came to the
He
office?
came in to apply, yes.
Okay. And you told him that the building intruded into the setback and it had to be built.
Well, it wasn't built yet. We building here, it needs to meet the setbacks and indicate on your site plan that it will.
Okay.
Most people get surveys when they're gonna do that, they know that we could.
Not really, unless it's real close. And yeah, they do.
He had his property pins marked. I mean,
Right.
We knew whether it was or not.
I don't think there was a question of where the line was. I think it was self-evident.
Sure.
If we have a hard time to determine the setback, and we're having a hard time determining where that line is, we'll request a foundation survey and it'll be dead on. In a lot of instances, we don't, if it's 15 feet off the property line or more, we can just pull the tape and be sure of it.
So he came in to your office and applied for a permit on April 6th of this year?
That's right.
Did you talk to him or Mr. Johnson?
I did,
You did?
yes.
And he gave you some supporting material?
That's right. That went along with his application.
And that shows 12 feet from the property line to the building.
Right. And so did you issue him a zoning permit? Brian did, later in June.
So Mr. Rothrock, you went out there to see if there was work, initially you went out there to see if there was work being done without a permit. There was. You talked to Mr. Soretti. You told him he just needed to get the permit and get back up to speed with the legalities. Is that a fair?
That's correct, yes, sir.
Get your permit and put the building, outside the setback. And everything was forgiven as far as starting without a permit. Is that,
Right,
okay.
yes,
The permit was issued to him on June 24th this year.
right.
So at some point, the building got built, and it got built within the setback.
Yes,
Said Mr. Soretti contacted the planning and inspections office and indicated the structure had been built and the left rear corner encroached into the setback 18 inches or so. Did you talk to him, or did Brian talk to him?
I did.
yeah, Brian had all the conversations since then.
So, Mr. Johnson, you told Mr. Surratt he was gonna have to move the building part of the structure?
That's correct.
Okay. Did he, when you had that conversation, he called, said, well, it's built and it's in the setback. Did you ask him why he built it in the setback?
I don't know if I asked him that specific question. I just told him it needed to be moved to meet the setback.
And you said you had a meeting. I said, Mr. Tony H.E. Withers met with staff. Were you the staff that met with him?
Me and Kevin at that time. When you come in.
And what was your understanding of Mr. Withers' role? Was he just a friend helping out Mr. Surratt?
Yeah.
Okay.
Just, EB, for the record, going back into zone permit, Kevin just pointed out there was, Mr. Shreddy had explored possibility easements, moving property lines. The property adjacent to him on that side is vacant. And I think he told me he had had some conversations with the previous owner, maybe wanting to buy the lot. So I'd put in the zoning permit that, continue those talks, if it, and I kind of give him some parameters of, if it's, number one, an easement can't be an option here, but a property line moving it could. And I advised him that's a possibility. If you've got permission, it'd have to be a lot line adjustment. You've got a minimum lot size you'd have to maintain over here. And I think that was the last conversation I had with that, but I know he was exploring that on that side.
Before it was built?
No, this was after he had received the permit and we had that discussion.
No, I think, let me clarify if I could.
Sure.
I think at one point, before Mr. Soretti built it, he wanted to line up the building on the pad. And we found out the pad was into the setback. And we said, well, the only way you can do that is to move the property line. And if you can talk to the neighbor about making a jog in the line and doing a lot line revision to accommodate that, you could. And he was exploring that as an option, or buying the property next door, where he could do that himself. And then I think that didn't work out. And so then the permit reflected that conversation. If you can move that, then you can do that. If not, the building needs to meet the setback.
Do you have a copy of the permit here?
Yeah.
Can you put it up there so we can see it?
We'll make copies.
Make copies for you.
But I think Mr. Schrader can correct me if we're wrong. I think we may have discussed that when he had called after he received the permit, that he may still be exploring that. I don't know what his options were in the neighborhood.
Can we hear from Mr. Schrader?
Oh, yeah.
When he's gonna be able to do that?
Well, I wanna see this zoning application, or the permit.
Sure.
I don't know about the rest of it, but I'm very confused. This is extremely confusing.
Please.
Is there something we can answer so that you're not confused? Is there something that we can give you more information?
No, you've helped me out. I think I'm up to speed on it now. I just wonder how confusing this process was to Mr. Spread. And I'll ask you that when we get to you in just a minute. But let's take a look at this zoning permit. I got it. Thank you.
Thank you, sir.
as you're reviewing the zoning permit, comments 2 through 8 are typical zoning comments we apply to all permits. It's just trying to cover some highlights of the ordinance that's typically need to be addressed or commonly addressed on projects, single-family homes. What you see in red was kind of the discussion and part of what we had with Mr. Shreddy.
Okay. Just a few more questions. Mr. Johnson or Mr. Rothrock, either one. The Blowing Rock ordinance section that controls these side setbacks is 16-12.4.
Yes,
And it says that in R15, the side setback is to be 12 feet.
that's right.
The accessory building as it is sitting there now. And if it stayed there, would it impair emergency vehicles such as fire trucks and ambulances?
No,
And if the building stays where it is now, would it create a fire hazard?
no,
And if the building stays where it is now, would it block or impede visibility on any street or highway?
no,
And if the building stays where it is now, would it be contrary to public health or safety in any way that you are aware of?
I don't know.
The property there at 369 Terry Acres Circle, are you aware of any serious problems with the lot that would make construction of this building extremely difficult?
No,
Do you think this building could have been built in other places on the lot without intruding into any setback?
yes,
Including closer to the house, just getting closer to the
Yes.
house? Would you say there are any unique features to the property at 369 Terry Circles Drive, Terry Acres Circle?
are there any unique features? Is that what you asked? Did you ask, are there any unique
Yes, are there
features?
Any unique features of the whole lot that you're aware of?
No,
I don't have any further questions. Any board member at this point have any further questions of Mr. Rothrock or Mr. Johnson?
No.
Mr. Shreddy, do you want to ask them any questions?
I want to make some clarification statements.
If you don't have any questions of them, we're ready to hear from you.
Yeah, it'd be great.
Come on up and take Mr. Rothrock's place. Now, Mr. Withers,
Yes, sir.
what's your role in all this?
I'm gonna tell you all that.
Okay, go ahead.
You're still hot, man. I'm about to freeze, so if I'm shaking a little bit, it's because I'm cold. My name's Tony Withers.
I'm just a personal friend of Fred's. I'm a registered professional engineer, retired. I'm not representing anybody professionally other than Fred, Mr. Sredi, who's my friend, been a friend for a long, long time. And we've been coming up here to his place, very nice place, for 4, 5, 6 years since he bought it. And I apologize for the informality of the application. I think it covered all the information that needed to be covered, and I think with the pictures I took and showed, I think I can answer some of the questions or all the questions you presented. And we don't have any issues with Brian and Kevin or anything they've done. Everything's been fine, perfect. They've been great to work with. No issues there. I'm gonna make that perfectly clear. They represent the town very, very well, and we appreciate that. So Fred is a friend of mine. I came up here. He bought a house on Terry Acre Circle. After a few years, he wanted to pave his driveway, so he did a crackerjack job and fixed his driveway up with the retaining walls and everything. It looked so good, he thought he would expand with the contractor into a patio, which kind of evolved into a patio, which then kind of evolved into an accessory building. I wasn't really involved in this process other than just talking to Fred during the process. It takes time to get things done up here with contractors. And I will tell you that Fred is a career IBM employee and a CPA, and probably not as familiar with this type of stuff as you are, as I am, having been in this business for a long time. Planning and zoning and setbacks and all those things are very important in our arena. Here again, the general public is not aware of property surveys, of setbacks, of all these zoning issues that you guys deal with all the time. I would also say that Fred is active in the community, makes donations for the flowers. He's a solid citizen about 40% of the year in Blowing Rock. I think that's important to point out. I think the property line is not parallel to the house, which is one thing that I think can create a little bit of an issue. And there was never a boundary survey of the property. We do have a pretty good idea where the property line was, and I think the measurements on there with a few inches are probably close enough for government purposes. If we're down to inches, then we're probably not, but I think a 24-inch encroachment is probably sufficient for what's needed without going to do the expense of an additional survey. So anyway, we came up here, and as I learned more and more about this, and Fred got into the situation and working through this, he was getting ready to spend a lot of money moving the house and tearing it down and do whatever he needed to do to modify it. I made the comment, why don't we at least ask the Board of Adjustments for a 24-inch encroachment into a 12-foot setback? It felt like it was a reasonable request to do. So I put together the application, met with Brian and Kevin, and that's what I did and submitted it, and that's why we're here right now. So based on that, I would say that the variance is minimal. I would say it creates no impact on the neighborhood properties. I would say it's consistent with the character of the neighborhood. I would say the topo and existing site conditions, including the line that's skewed to the house, which creates a problem at the rear of the building, not the front of the building, might impact some of the reason for the encroachment. I would say the variance will not impair public safety or interfere with the purpose of the zoning ordinance. I would say the variance is minimally needed for the relief requested, and the converging might, as I said, present a little bit of a typical situation. And I would say, based upon my experience in this business, representing other property owners on a multitude of issues like this, that I don't see any real benefit in making Fred spend a whole bunch of money and the hardship to modify an existing well-built building that is attractive, matches the house in color and architectural standards, for an outbuilding with just a corner that's only approaching about 20 inches into the setback line to meet a code when no malicious intent was intended. I would just say that, you know, an error was made, no question about that. But I just think it's a hardship on him to have to spend that for something that's that minimal. It doesn't impact, any of the adjacent neighborhoods for all the reasons we talked about. I think the letter of the law has definitely been violated, but I think the spirit of the law and the intent of the law is certainly acceptable. And I welcome any questions or comments or thoughts, and I can explain any of these pictures that we put up. He's certainly proud of his property and enjoys his property, and he's done a very nice job. He's improved the value of the property substantially, which I'm sure will be reflected in future property tax to the town. So anyway, that's all I've got. If you've got any questions for me, and then if Fred feels like he needs to answer any questions.
We have some questions, but first of all, I'll ask the representative from the town if you have any questions of Mr. Withers. Do you, Mr. Johnson? Mr. Rothrock, any board member have any questions of him?
Tell me one thing, how far back, how much along the wall is in the encroachment? I mean, how many feet is down the line, for example?
I'll explain, okay, stop right there.
Yeah.
The line comes down like this. The front corner of the building, which is up here,
Sure.
is quite a bit over.
Way in.
When you get to right there, you're about at 12 feet, so now we're going into the building, so that back corner is what they had. And it looks like that's about 4 feet, so I think we're below the foundation issues based on that. Tape measurement I laid there just to get a height in it. But I was trying to represent where it hit,
Yeah, I can see the picture from there. Yeah, that's good. Good.
and I misspelled where, so I apologize on that.
It's probably about halfway down the building.
Yeah, I'd say about halfway's probably good. And then if you want to go to the other one, maybe you understand the rest of the pictures.
Yeah. No, I got
Trying to graphically.
got what I want to know. Got what I want to know. Yeah, thank you.
Anything else, Mr. McGee?
No,
Any other board member have any
Who
questions?
built this?
Who built it? I don't know who the contractor was.
And the contractor, well, okay.
You did hire a contractor?
Yes, sir.
Who was the contractor?
Independent contractor, anyone know his name? Or-
Sure, yeah.
I don't have my phone.
All right, we'll get back to you in just a minute. Mr. H.E. Withers,
Yes.
Mr. Tony Withers,
Yes, sir.
do you mind if I get your address?
I'm 6116 Oxfordshire Court, Raleigh.
Oxfordshire Court.
Raleigh. I've been a practicing engineer in the state of North Carolina for about 45 years.
What's your zip code?
27606,
Okay, and what kind of engineer are you?
civil.
Were you visiting Mr. Soretti before he built all this?
I've been visiting since he bought the house. I helped him research the area. And
Back in the talking stages, why didn't you suggest to him that he check to see if he needed a permit?
I think we talked about permits during the process. Here again, that wasn't what I was, I would come up from time to time and driveway was dirt and ran my car into one of the rocks that was sticking out of his wall. Decided he needed to widen his driveway and do a little better job with it, so he ended up making quite a bit of improvements. And he was gonna build a fire pit initially, and then the fire pit all of a sudden turned into, a pretty big project. I was surprised when I actually saw what he ultimately built. I hadn't really been up here, I guess, in a year. All this was done since I've been up here.
I don't have anything else. Anybody else have any questions on it? Mr. Soretti, can we hear from you?
I'd love to speak.
Come on up. The contractor you use can
Juan Guzman Padilla. Juan Guzman, Guzman, Padilla. I believe that's
Juan Guzman
Padilla.
Padilla.
Padilla, Padilla.
Okay. You've been wanting to tell us one or two things as we've been talking to the town representatives. Would you like to go ahead and speak your piece now?
Yeah, I would love to.
Please.
Okay, so this, since we're kind of got into this sidebar on, retaining walls, patio and all that, I want to go back a little bit farther in time when we really started this project, which was probably May of 2025. And there's where we hired a mason to tear down the retaining walls we had, which were falling apart, and put in new retaining walls, as well as it led to a driveway and 2 stone pillars on either side of the driveway as you enter from the street. And the electrical contractor I hired at the time, I'm drawing a blank, Roby Services. They're out of Boone. They said we needed a permit for the running the wires. So I said, fine. They worked through Kevin and Brian. I did not interface with them at that time. I actually dug the line to make sure it was 18 inches myself personally, to satisfy the code for the wire. They had to go from the house to the street where the 2 lights were. At that time, Kevin came back. I was not there. My wife and an electrical contractor were there. And at that time, in addition to, certifying the line was okay and dug at the right depth, he started to look at the retaining wall for the parking pad. And he went up to it and he said, well, I'm 6 feet and that's taller than me. But, you got 2 feet of, air, that's parallel to, the same height as the road. So really less than 6 feet. And basically told my wife, proceed.
And this was last year.
This was probably May, June, July of last year. So I said, well, obviously probably should have got a permit, but we didn't, but we're going to proceed. That was the only communication with Kevin at that time. And kind of fast forward, I said, well, I'm going to do this shed. I need to get a permit. It wasn't prompted by anybody. It was me.
Okay.
I went into the office early April with that permit that you've seen, and presented it to Kevin. At the time I went into the office, he told me about my neighbor, my new next door neighbor, that was questioning the drain that we put in as part of the drainage for the new driveway. And I said, okay, well, this is the first I've heard of that. I didn't know that the drain was an issue with my new neighbor. I never even talked to him. And I said, if I had known that, I would have cut the drain. In fact, that day I went back and cut the drain so it wouldn't be intruding on his property line. But between March, which I was not aware that they arrived on my property to evaluate, apparently it all got precipitated by him coming from my neighbor questioning my drain. And that's when he said, whoa, should have got a permit. And I never communicated with Kevin about I needed a permit on all that. And so I, without any knowledge of March happening, only knowledge I had was my neighbor about the drain on the other side of the property. I brought in the permit unprompted by any human being. I did it on my own because I thought that was the right thing to do. I brought the permit.
Relating this to the drain,
The permit for the shed,
had you already had a conversation with Mr. Rothrock? about
not
that?
prior to that.
You came into their office?
I brought in the office and brought it to Kevin, but he was implying that the only reason I came to the office is because of some conversation I had between him coming in March and me coming to the office. That conversation did not occur about anything related to the shed. The only conversation I had with Kevin was related to the drain on the other side of the property caused by my neighbor. That was the only conversation. No conversation. He did not suggest that I bring in a permit for the shed. That was unprompted. I brought it in myself without any cue from Kevin or anybody else.
So on April 6th, had the foundation.
Somewhere around, yeah, I mean,
Retaining wall, had that already been built?
the pad was done. And
That's-
that's
and
why I
we're call-
sketched,
so are
I
we
sketched
calling
out
that
the,
Retaining wall, pad, foundation, what are we calling that?
well, that's the pad, that's where the shed was built, so all of that was done when I presented the permit to Kevin.
So, okay, that was finished on April 6th, the pad.
Yeah, just the pad. And then I brought in the permit.
The patio is what you call the pad?
No, the pad, I'm calling the pad where the shed is at, right
It's
here.
under the shed.
Related to the permit, the permit was only for the shed on the pad, which I'm calling was the structure under the shed, is the pad I'm referring to.
Okay.
Is that clear?
Is there a concrete floor
Yes.
as you walk
Certainly,
in?
yes.
So there's a floor.
Yeah.
Okay.
When did you first hear that the building, this plan, was gonna encroach into the setback?
Kevin came back out, and I don't know if it was just Kevin or Brian or both of them. And they laid a board on the concrete pad and said, this is where you need to build it,
Build what?
the shed.
Because of the setback,
Correct.
okay? And that isn't where it ended up getting built, right?
No, I made a decision based on my view that was in the spirit of the law, not maybe the legality of the law, the letter of the law, however you want to call it, because this pad was fine. But as soon as I put a structure on it,
Right.
it became bad. Somehow, that was nebulous to me. I'm sorry, that's just, and I decided to build the structure on the pad because I did not think it affected the spirit of the law. Because the pad was okay, but the building was not okay. That's why I took the risk and why we're here today. Unfortunately, I'm dragging you all in here, but I believe that what I did violated the letter of the law, as Tony's already said, but I do not believe it violated the spirit of law, particularly given the pad is okay.
Just for the record, I disagree that the pad's okay. Even looking at your permit, that was issued in June that you applied for in April, you didn't apply for a permit for the pad, which you should have. And it's certainly we're gonna call it a retaining wall, it's certainly over 4 feet in height, it requires an engineered design and inspection. No retaining walls over 6 feet in height are permitted within the side rear yard setback, and Kevin said when he was talking that the back side of that pad is 6 to 7 feet. And the portion of the building within the 12-foot setback will need to be removed to meet it. Failure to meet the requirements of the ordinance will result in a violation of this permit. And if we're gonna call it a foundation survey may be required. I don't think any of this meets the code.
Okay, well, this is so this whole,
And I'd also like to just say, just kind of jumping ahead.
somehow we got an after the fact permit, I've been told supposedly on everything but this storage shed. So you're saying it's not in code, but the town of Blowing Rock is saying it is, so I'm confused.
Well, I'm reading this, that concerns me. It concerns me as much as the building.
I'm just confused, completely confused now. Because I was not anticipating getting a discussion on something that in theory was approved that I didn't apply for.
Well, it wasn't approved. You said it was built before you got a permit.
I was not aware I had to get a permit.
Well, that
let's-
doesn't matter.
Well, let's stick to just.
Can we stick to the facts of this variance, please?
Yeah, let's jump ahead to hardship did not result from actions taken by the applicant or the property owner. That's state law.
Okay, you got me there. All right, so
If there's facts that refute that, I'd love to hear them, but I haven't heard a single one.
okay, so I'm not gonna debate that point.
Mr. Sorrell, you're obviously a nice guy, but you can't just decide it's okay to break the law a little bit. It just doesn't work that way.
And I'll also say, when I drove by your house, the driveway, everything, it's gorgeous.
Pardon me?
The driveway, everything, it's gorgeous when I drove by there yesterday. So I'm not criticizing, I'm just saying the law is the law. And you just can't decide not to follow it.
All right, is there anything else you want to say?
No, I have nothing else to say unless you have something to say.
I can make one final thing. I could.
And I think we acquiesced that we agree that the letter of the law was violated. I don't think anybody ever said that, but I think based on the circumstances, the corner of a building and the 12-foot setback is certainly worth a request for mercy on the court, or whatever you call it, prayer for judgment, in a situation like this versus the
There's
hardship.
nothing wrong with asking.
Yeah,
That's the old
and-
saying.
That's right. And so we're here under those circumstances. He certainly understands the cost implement and the implementation of moving, his building or taking 2 or 3 feet off the building to get it within but we thought we'd come and ask and hope as a good citizen, the opportunity for mercy would be a possibility. And that's all we can do.
Yes,
I'm actually one of the neighbors.
yes.
Do I have permission to make a comment?
If you want to get sworn in, and you gotta get
Yes, sir.
sworn, okay. Yes, sir.
I really didn't intend to speak.
Do you solemnly swear that the evidence you shall give to this body in this matter being heard shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Tell us your name and your address, please.
Yes, sir. My name is Saeed Khan. I am a semi-retired physician and I live at 277 Terry Acres Circle.
Okay, can you spell your name for me?
S as in Sam, A as in Apple, E as in Edward, E as in Edward, D as in David, K as in Kilo, H as in Helen, A as in Apple, N as in Nancy. As you can see, I've
One more
done-
time on the last name.
You said that so many times. You gotta
I've said
slow
it so
down.
many
I've
times.
said it 100 times. Once more. a
Pick it
little
up,
slower.
sorry, what's your,
K as in Kilo, H as in Helen, A as in Apple, N as in Nancy.
okay, all right. And do you mind giving us your address?
277 Terry Acres Circle, Blowing Rock, 28605.
Okay. What did you want to tell us?
Well, we actually live on the street with Fred. In fact, today's the first day I found out your last name. But we have been neighbors for now about 4 or 5 years. And one of the things which I don't think anybody's really mentioned is the post-Helene effects on our drainage, because we're on a ridge. We had massive issues with erosion. And most of my neighbors, including myself, we have spent a substantial amount of money putting in newer retaining walls, and I have a brand new house. We've also had to put in new drainage and everything else. When we saw Fred doing this last year, also, his property was also getting eroded. So as a person who lives on the street, walks on the street, I just want to say is that the structure in itself, if someone had actually not told me that it was like 24 inches out of compliance, you'd never know the difference. So I agree. I mean, laws are there for a reason, but there's also compassion. Making him now tear the whole structure down or modify it. I mean, we've all spent substantial amount of money between, I would say, each individual, between about $50,000 to about $120,000 just on retaining walls,
because of, and it is a steep slope.
Mr. Khan, can you
Doc.
reference where you live to the board up there?
Oh, absolutely. Right up there. That's me, yes, my house. There, sir.
Okay.
So we do have a very steep mountainside, and we have had a lot of trouble, especially post-Helene, with erosion and drainage. So yes, he probably did break the law, but I really do believe that we should also be in the business of compassion.
Thank you.
And thank you for your time.
Thank you. Any board member want to ask any questions?
Thank you.
Thank you very much. Mr. Soretti, do you want to, anybody else you want to call as a witness or anything else you want to say?
No, that's it from my standpoint.
That's it.
Okay. All right. Fellow board members, you ready to start working on findings of fact? The applicant is Fred and Sandy Soretti. The owner of the property in question is Mr. Soretti. I noticed the name on your deed is Alfred Soretti and Sandra Soretti. You mind if we use your proper name?
Sure.
The address of the property in question is 369 Terry Acres Circle in Boiling Rock, North Carolina. The property is also identified by Watauga County PIN number 2817-43-7159-000. The property is zoned R15, and the applicant wants the following. The applicants have built an accessory building, which the applicants call a shed, on the western side of their property. The dimensions of the accessory building are 11 feet 8 inches wide by 13 feet 8 inches long. The building is built with a portion of the building encroaching into the 12-foot side setback required by Boiling Rock Land Use Ordinance Section 16-12.4. No construction is allowed inside the 12-foot side lot setback. The amount of the encroachment is 25.5 inches, 28.5 inches. And the applicants are seeking a variance of, Mr. Shreddy, would you like to change your application to 30 inches instead of the 2 feet you were asking? I don't think it's gonna make a whole lot of difference, but
I'm not gonna debate, a few inches, I don't think it's.
all right, well, let's leave it the way it
affects
is.
anything, decision the way.
The applicants are seeking a variance of 2 feet from the required 12-foot side setback after the accessory building has already been built. Other witnesses in the case were H.E. Tony Withers, a civil engineer and friend of the Sorettis. And his address is 6116 Oxfordshire Court in Raleigh, North Carolina, 27606. Other witness was Mr. Saeed Khan at 277 Terry Acres Circle, Boiling Rock. There are no other parties who stand to come into this case. The applicant did provide drawings or sketches or plans. The town of Boiling Rock has provided and given all necessary legal notices of this case and this hearing. There was proper notice of this case and hearing given to all property owners for property abutting the parcel of land which is at issue here, and proper notice was given to any other persons entitled to receive notice. 14 notices were mailed out. The applicant did receive a copy of the planning director's staff report prior to the hearing. What the applicant is proposing would not, yes, what the applicant is proposing would not impair emergency vehicles such as fire trucks and ambulances. What the applicant is proposing would not create a fire hazard. What the applicant is proposing would not block or impede visibility on any street or highway. Unique features of this property include none. There are none. This structure requires a zoning permit. A property owner who wants to build a structure like this, accessory building, is required to obtain the necessary permit before any work of construction is started. When completed, the accessory building encroached into the 12-foot western side setback by 28.5 inches. That number includes an eave at the top. There was a place on the lot. There were places on the lot where this accessory building could have been built without encroaching into any of the setbacks and without the need of a variance. Zoning enforcement officer, excuse me, planning director Kevin Rothrock went to the Soretti property for the best possible building work without a permit in March 2026. Later, Mr. Soretti came to the planning and inspections office in person and was told the accessory building he wanted to build would encroach into the 12-foot side setback. And it could not legally be built as planned. Mr. Soretti applied for a permit and provided a site plan, which showed the accessory building located outside the side setback. And within the zoning requirements. He applied for a permit on April 6, 2026. The permit was issued to Mr. Soretti on June 24th, 2026. Mr. Soretti did build and complete the accessory building. And he built it encroaching into a 12-foot side setback, knowingly. Does any board member want to add any facts or want me to change any facts?
I don't, I move that we adopt the facts as ED just stated them.
Okay.
I'll second the motion.
Any further discussion on the facts?
No.
All right. All those in favor of adopting the findings of fact as I have just spoken them, say aye. Aye. It's unanimous. I move that we adopt the findings of fact. Well, we've come.
Just did that.
We just did that. Thank you. I'm thinking about
Brandon
conclusions.
did it for you.
He did. Thank you. And the board adopted the findings of fact by a unanimous vote.
Yep.
We move now to conclusions of law. Based upon the evidence presented and the facts shown above, the Board of Adjustment does or does not, let's put it that way, find substantial material and competent evidence exists to conclude that in this case unnecessary hardship would result from the strict application of the regulations. It shall not be necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. I make the motion that we either find he has met his burden or we do not. Is there a second?
Can you repeat the motion, please?
Sure.
I'd make a motion that we do not find substantial material and competent evidence exists to conclude that in this case unnecessary hardship would result from the strict application of the regulations.
Well, we could do it, we could word it that way, and then if you think he had, you would just vote the other way.
Yeah.
Louder. Thank you.
Okay,
If you disagree with my motion, you can just vote no.
but I like the idea we either vote yes, he did, or no, he didn't. Is that okay? That's what I want to do. I probably didn't articulate it. So my motion is, that we take a vote and find that you vote, your choices would be, he met his burden and he has complied with factor one, or he has not. He has or he has not. What do you think? Am I getting too?
I don't know how you vote on that. It's yay or nay, so.
Mr. Chairman, for purposes of our record, it would be appropriate to take a finding, or a finding as to whether there is or is not material and competent evidence as to the unnecessary hardship. So you can certainly vote in favor of whatever the proposed finding is, and if that fails, then take an alternative
Okay.
motion. That would be the better approach, if I may interject.
Okay, that's what we've been doing in the past. For some reason, I decided to get creative tonight. In the past, I've always made the motion to say, we find that he has met his burden. And so you would, if you find that he has met his burden, you would say yay. And if you disagree and think he hasn't met his burden, you'd say nay. Everybody with me?
Yeah.
Okay, so let me do it again. Based upon the evidence presented and the facts shown above, the Board of Adjustment does find substantial material and competent evidence exists to conclude that in this case, unnecessary hardship would result from the strict application of the regulations. It shall not be necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. Is there a second?
Second.
All right, Mr. Walker, seconds. Any further discussion? All right. All those in favor of finding that he has met his burden and has satisfied factor one, vote yay. All those that find he has not met his burden and satisfied factor one, vote nay. Nay. So,
I said, I'm yay.
you're yay. He met his burden.
Yes.
I'll be a yay too then.
Okay, so the yays are Mr. Goodson and Mr. McGill. Nays, he did meet his burden and doesn't satisfy it, are Mr. Schiller, Mr. Springs, and Mr. Walker. Have I got that right?
Yes.
Moving to the second. Based upon the evidence, this is the second factor. Based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or general public, may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make reasonable accommodation under the Federal Fair Housing Act for a person with a disability. So the motion is that we find he has met his burden and has satisfied factor two. Is there a second?
Second.
Mr. Walker seconds. Any further discussion? Okay.
Mr. Chair,
Yeah.
part of the motion, on each of these factors, it's preferred that the maker of the motion state the facts that would support or not support whatever your ultimate finding would be.
Okay.
Case law is generally wanted the board not to simply recite the element of the variance, but also cite to some facts and the evidence that it's.
Okay, all right.
I've got a question. Haven't we already done that?
Sir?
Haven't we already done that? We made our findings of fact, which would say be the,
Yes, sir.
like in a court opinion, be the
Yes.
introduction. And then now we're applying the law to those facts. Why would we need to repeat those facts?
Because if this is reviewed by a court on appeal, they would want to know specifically what facts the board found to be persuasive as to this, for example, whether it is a peculiar to the property such as location, size, or topography, and what those facts were.
And make all that part of a motion?
Yes, sir, that would be preferred. Otherwise, you run the risk of the court remanding it back to you for further explanation as to why you reached that conclusion.
Okay, let's go back and do one. Factor one again. Mr. Eggers.
Can I take a shot at this?
Sure.
I move that based upon the facts that the board just adopted, as stated above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case, unnecessary hardship would result from the strict application of the regulations.
Yes, sir. Are there specific factors that would relate to an unnecessary hardship you wish to cite to? That motion technically failed before the board. So what would?
Well, I just added that we're.
Well,
I don't understand how we can sit here and repeat all these facts that we just approved
Yes, sir.
as part of a motion.
Well, he's right. They do want to see under each conclusion, we find or do not find for this reason. The problem is, if I make the motion that we find,
And then if he states all the facts, and then we vote against it.
If the board's majority conclusion is that the applicant has not met his burden of an unnecessary hardship, the board can find that while it may impose a hardship on the applicant to comply with the ordinance, it is not an unnecessary hardship for whatever specifics you wish
How
to
about-
find from the evidence.
how about this, Mr. Eggers? How about we do a motion that he has satisfied it, or he has not. We take that vote, and then the winning, in this case, the nays, then add on supporting facts.
Yes, sir. It would need to be facts that would support a successful motion is generally what you're looking for. However, I will say that in a variance, unless a motion carries by at least a 4-1 vote, then that motion that you have proposed would not pass.
Right,
The motion here did not pass, so there was not a conclusion by the board that an unnecessary hardship had been shown.
Could we, the factual support is that he produced absolutely no evidence of unnecessary hardship. So that statement, the applicant has produced absolutely no evidence of unnecessary hardship. Could that come after we took the vote? And then add that?
Yes, sir. The board would be within its purview. I would suggest that find that the applicant has failed to carry his burden as to an unnecessary hardship rather than a finding that there's no evidence produced. Because the burden is on the applicant. It's not necessarily a summary judgment type burden. It's whether it's carried.
Well, yes.
You're also implying that when the motion is made, we already know what the outcome's going to be in order to include the facts that support the outcome in the motion.
The making of the motion needs to propose facts to go along with his motion, is what I'm saying. Now,
Okay.
if those facts aren't supported by a majority vote, for example, it would fail.
And then
Okay.
we need to make a new motion with new facts?
Yes, sir. Something that can.
Should I simplify this discussion and say, I'm not gonna appeal the decision, I'm gonna live with the decision, so you don't have to worry about whatever decision is made, it's gonna be based on compassion, no other decision. So I'm not gonna, I will declare I will not appeal this.
We appreciate that. We gotta do it in a professional manner. Okay, factor one, we found it has not met its burden. I am now making a motion that we say, and we say the reason he has not met his burden is he has not provided evidence of unnecessary hardship. A second motion for number one. So going back to number one, we've taken the vote, it's 3-2. I now make the motion that we say he has not met his burden because he has not produced sufficient evidence of an unnecessary hardship.
And that would be sufficient for purpose of that finding.
So I'll second that.
All right, so Mr. Walker seconds that. Any further discussion? All those in favor of adopting the
Motion. Aye.
the motion, say that he has not produced sufficient evidence of unnecessary hardships. Say
Aye.
aye. Mr. Woods, you're a nay?
I'm a nay.
You're a nay?
If you think he's met his burden,
I'd have to say he has not. I'm sorry.
so it's 4-1.
Okay, so, well, but he's still got his vote on.
But
Just the question, did or did not? Are you gonna, you have voted that he has met his burden. Are you gonna stick by that? While not,
The motion is that he has not provided sufficient evidence of a burden.
he has not.
of unnecessary hardship.
Yeah.
You think he has not provided sufficient evidence of an unnecessary hardship?
I vote for was that he thought he had. Isn't that right? Yeah.
You,
It was a yay. It was a,
you did,
were you doing, we still on one?
we're
We back
still,
on one?
we're still on one. We want to,
I'm not-
connect it somehow with the facts.
Yeah.
And so I'm saying the connection with the facts is he just hasn't produced sufficient evidence of unnecessary hardship.
Well, I feel sorry for him, but I don't think he has. I think he knew he needed to keep it within that 12 foot and then he slipped over. So
Okay.
I'm afraid he has not. I'm just, it's frustrating, very frustrating.
All right.
Because I think you ought to let it go and let him have it, but nobody's ever gonna know. But anyway, this is what we gotta do, so we gotta do it.
Okay.
Yeah.
All right. The applicant has not provided sufficient evidence of unnecessary hardship. The vote is 4-1. With Mr. Goodson voting nay. He has produced enough. Factor 2, based on the evidence presented and the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case, the hardship results from conditions that are peculiar to the property, such as location, size, or topography, hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make reasonable accommodations under the Federal Fair Housing Act for a person with a disability.
I'd like to make a motion.
Go ahead.
So I move that based upon the evidence presented, the Board of Adjustment does not find substantial material and competent evidence exists to conclude that in this case, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. The evidence presented did not suggest any conditions peculiar to this property, including its location, size, or topography. So,
I second that.
Any further discussion?
No.
The evidence produced, help me out, Mr. Walker, finish up your sentence.
The evidence produced does not,
I can repeat your motion if you wish, sir.
please.
Sorry. I believe the motion, as Mr. Walker said, the board did not find substantial material or competent evidence related to the conditions of the property, as the evidence did not support any condition that was unique to the topography, location, or size of the property. Is that correct, sir?
Right.
Okay. Does not show location, size, or topography presenting any hardship. Fair enough.
That would be legally sufficient if that's Mr. Walker's motion.
Yes.
Yeah.
Mr. Walker?
Aye.
As the evidence produced does not show location, size, or topography presenting any hardship. Okay, so on this one, the motion is that we did not find evidence, he did not meet his burden. All those in favor of, if that's correct, he did not meet his burden, he did not satisfy factor 2, say aye.
Aye.
Aye. Are there any nays? Are you a nay?
I'm gonna, hey,
You know, nice.
Okay, so we got, it's unanimous. All aye. Factor 3, based upon the evidence presented and the facts shown above, the Board of Adjustment does not find substantial material and competent evidence exists to conclude that in this case, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the grant of a variance should not be regarded as a self-created hardship. The applicant knowingly constructed the accessory building with it encroaching into the 12-foot side setback. That's the motion, that he did not meet his burden. Is there a second?
Second.
Second from Mr. Schiller. Any further discussion? All in favor of finding that the applicant has not met his burden on factor 3, say aye.
Aye.
Aye. Is it unanimous? It's unanimous. The fourth factor, based upon the evidence presented and the facts shown above, the Board of Adjustment does not find substantial material and competent evidence exists to conclude that in this case, the requested variance is consistent with the spirit, purpose, and intent of the regulations, such that public safety is secured and substantial justice achieved. Substantial justice is not achieved when granting the variance would be injurious to the neighborhood or to the general welfare. Building, the accessory building knowingly into the side setback because applicant thought the encroachment was minimal. And that is not within the spirit the regulations. Is there a second to that motion?
Second.
Mr. Schiller seconds. Any further discussion? Hearing none. All those in favor of finding that the applicant has not met his burden, and there was not substantial material and competent evidence existing to conclude that in this case, the requested variance is consistent with the spirit, purpose, and intent of the regulations, such that public safety is secured and substantial justice achieved. Building the accessory building into the side setback because the applicant thought the encroachment was minimal. And it is not. And that is not within the spirit and intent of the regulations. All those in favor, he hadn't met his burden, say aye.
Aye.
Any nays? It's unanimous.
For this one, I will restate this.
I'm sorry, what?
For the number 5, I move that, consistent with the conclusions of law just discussed, the Board of Adjustment does not grant the applicant a variance, period.
That's your motion? Okay.
That's my motion.
And I'll second that. Any further discussion? All in favor of the motion that we not grant a variance, say aye. Aye. Mr. Goodson?
Nay. I said aye.
Mr. Goodson? Nay. The rest are aye. A deadline to the correction of the problem. In other words, you've got to correct this situation within, what do you think's reasonable? 6 months?
6 months.
What do you think's reasonable?
I think 6 months is reasonable. I think it should be done sooner. 6 months.
Well, you got up to that point, up that point.
I'm gonna hire a surveyor to get the actual line, because I don't wanna do this and find out we're in each.
Yes.
Yeah, that's correct. What you should, yes.
The applicant,
Sorry. That's all right.
the applicant must,
9 foot from your neighbor,
Mr. Chairman.
9 foot from your neighbor.
Since
Put a lane. That's all you gotta do.
That generally would conclude your work as far as time to
Or
correct the
2 feet.
problem is something that would be handled through staff as an administrative matter.
yeah,
And
but,
they can-
but the town ordinances give us all the authority and power of the administrator.
Yes, that's where I'm headed.
So we're gonna go ahead and do it. So we're gonna do it.
That's generally where that goes, they can grant those additional terms, however, since the board is hearing the matter, the board can impose those conditions and give staff direction if you choose to do so,
Thank you.
which is the second part of my presentation.
I'm not gonna write that down, but thank you. The applicant
Quite all right.
must remove all of the constructed accessory building that encroaches into the western side setback within 180 days of the filing of this decision. This, I think make the motion that we say that. The applicant must remove all of the constructed accessory building that encroaches into the western side setback within 180 days of the filing of this decision. Is there a second?
Second.
Mr. Walker seconds. Any further discussion? All those in favor of adopting that term, say aye.
Aye.
Aye. It's unanimous on that. This decision is effective after review and approval of the written decision by all participating board members and then filing with the clerk, which means I will type it up, I will show it to all the other board members, and if they see no errors or mistakes in it, they'll tell me, and I will tell the clerk that she can proceed with filing. I now make a motion that the board adopt the conclusions of law that we have just articulated. Is there a second?
Second.
Second by Mr. Walker. Any further discussion? All those in favor of adopting the conclusions of law just stated, say aye.
Aye.
Aye, that's unanimous. And I now make a motion that we conclude this meeting of the Lorillard Board of Adjustment. Is there a second?
Second.
Mr. Goodson seconds. All those in favor of ending this meeting, say aye.
Aye.
Aye, it's unanimous. Good evening,
Thank you
y'all.
all, appreciate your time.
Yes, sir.